So I've been out to Montpelier many, many times, and they have an exhibit out there called The Mere Distinction of Color that was based upon a reference, a comment that James Madison made during the Constitutional Convention, where he, another slave owner, decried that this was a terrible institution based upon, as he said, the mere distinction of color. I don't know about you, but every summer when I was a kid, my skin color changed. It got from the ruddy white that you see now to a much darker hue. Isn't it remarkable that that on the basis of something like that is superficial and beyond our control to a great extent, and which is variable, we nonetheless decided that a whole group of people were going to be relegated to servitude, and oftentimes, I'm sorry to say, death. So people recognized that this was a nasty thing, but nonetheless, the slave power, the political power of slave owners in the South was such that our original Constitution contained many, many provisions that not just tolerated slavery, but protected slavery. And you can see them at James Madison's Montpelier in an exhibit called The Mere Distinction of Color, which includes many, many poignant displays, but perhaps the one that most strikes me is a tabletop display. It's about 6 feet long, 2 feet wide, covered in plastic, and it's a representation of the original 7 articles of the Constitution, the ones that were signed in 1787 and ratified in 1788. And there are a bunch of buttons along the edges of this display. And of course, you walk up to it, what are you going to do? You're going to press the buttons. And every time you press a button, a clause lights up. And the clauses that light up are all the clauses that protect slavery. And it's remarkable. Slavery was baked in to our foundational legal document, our Constitution, our fundamental law. Most of us know about the Fugitive Slave Clause. Most of us know about the 3/5 clause, which most of us quite appropriately consider to be horrible, but not for exactly the right reason. Oftentimes you'll hear people say, well, our Constitution said that Black people are only 3/5 as good as white people. Well, that's offensive, absolutely, but it's actually the opposite. Southerners wanted Black people to count as 100% of a person for purposes of representation in the House of Representatives. It was the Northerners who said, wait, you can't do that. I mean, if you're not going to allow these Black people to vote, if you're going to treat them as property rather than people, they shouldn't count for anything in terms of representation. So the compromise that was reached was 3/5, which incidentally gave slave owners a numerical advantage in the House of Representatives and thus in the Electoral College for decades thereafter. So the slave power was powerful, and the slave power put these basic provisions in the Constitution that protected slavery. One provision you're probably not familiar with, I certainly was not myself until I started studying constitutional law and teaching it, was that a very obscure reference that spans Article 5 and Article 1, the gist of which is that there is one part of the Constitution which by its own terms could not be amended for 20 years, and that was a protection of the slave trade. So from 1788 to 1808, nothing could be done to prohibit the slave trade, which was arguably the worst part of a horrible institution. Slaves coming over would oftentimes be tied up and not allowed out of their hold, where things were utterly miserable, where they might die, where they were confined in their own excrement, where the person next to them might be dead and rotting. It was a horrible, horrible thing. And quite appropriately was the focus of a lot of abolitionist sentiment, but our Constitution protected that worst part of that terrible institution for 20 years. So when you go to Montpelier, or when you simply study the Constitution, you at some point will realize that slavery really is our original constitutional sin. And we were, I hate to say this because I love our country too, we were a slave republic. People who look like me, people who were white and were male and who had property, by golly, we got a fair shake, and we were to some extent, equal with one another. But all of you ladies, no, not true. And people of color, definitely not true. So it was a rough time. Okay, that was the Constitution that Abraham Lincoln encountered when he was elected, not as an abolitionist, but as someone who was anti-slavery in 1860. Let me explain the difference. Being anti-slavery meant that you didn't like slavery, that you didn't want slavery to expand to the Western states that were being added to the Union. But it was different from being an abolitionist, because an abolitionist simply wanted to abolish slavery. You see the difference? An abolitionist was more radical. That was the John Brown perspective. Abraham Lincoln said, I don't like slavery, but he was also very, very specific. He said, I don't believe that as president, I can abolish slavery where it exists, because according to our Constitution, as elucidated by the Supreme Court in the infamous Dred Scott decision, slaves were not people. Slaves were not American citizens. Slaves were property. And when you combine that fact with the Fifth Amendment of the Constitution, which says that the government can't take your property without compensating you, well, there's a problem, isn't it? The national government can't abolish slavery unless it's willing to take possession of those slaves and pay the slave owners fair market value for them. And again, the amount of money that was at stake was astronomical. The national government couldn't even afford to do something like that. So Abe Lincoln didn't like slavery. Abe Lincoln wanted slavery to somehow disappear. He didn't want it to spread to the West, but he was not an extreme radical. He was not an abolitionist. Nonetheless, he was the first president in our history to be elected on an anti-slavery platform. And the Southern states were very, very concerned about this. And so it was after his election in the fall of 1860 that we entered something we now call the secession crisis. State after state, starting with South Carolina in the South, declared that they would no longer be part of our national union, that they were going to go their own way. Many of them citing, of all things, the Declaration of Independence and the fact that we had seceded from the British Empire. They cited that as their precedent. And one after the other, Southern states, first in the Deep South and eventually in the Upper South, seceded, and eventually they formed something called the Confederate States of America. They ratified their own constitution. You can Google it. It's called the Confederate Constitution. And they were very, very explicit in that Confederate Constitution that they were founding a new nation where protection of slavery would be very much front and center in their Constitution. Indeed, even before the Confederate States came together to form a constitution, many of them in their individual declarations of secession very explicitly said they were doing so to protect the power of those states to engage in slavery, to protect slavery. I realize to this day it's somewhat controversial to say this, but slavery was the cause of our Civil War. Many people will say it's about states' rights. Well, I understand that, but states' rights to do what? Well, to have slavery if you're a Southern state. In the North, it was about the states' rights to not allow slavery in their states, because remember that fugitive slave clause? If I'm in Illinois, if I'm in Ohio, if I'm in Michigan, if I'm in New York, where my state government says slavery is not allowed here, well, I'm obligated by the fugitive slave clause to capture and return fleeing slaves to the South. So guess what? Slavery does exist in New York or Ohio or Michigan or Illinois, because we have to acknowledge the power of the slave owners to have their property returned to them. So yeah, you can characterize it as a battle over states' rights, or even a bit more attenuated, a battle over tariffs, which is even less true. But it really comes down to slavery. That was the issue. And as Lincoln himself said during the Lincoln-Douglas debates in 1858, the House divided itself cannot stand. He was quoting the Bible there, of course. So that was the issue from our founding to the middle of the 19th century. And although it's very difficult to face up to this, and many people resist it, including me. I mean, it's a subject that most white people are extremely uncomfortable with, and I understand that. But you cannot understand our history unless you understand the history of slavery, and unless you understand that our greatest constitutional crisis, the one war we've ever had over the Constitution, was over the issue of slavery. So that's the Constitution that Lincoln inherited. And to his credit, he recognized that his power to do anything about slavery as president was very limited. But again, this did not satisfy the Southern states. So one after the other, starting in 1860 and into the spring of 1861, these states seceded. Lincoln actually didn't do much about it when he first came into office in March of 1861. He tried to talk to the Southerners. He tried to reassure them that he was not going to abolish slavery, that he didn't have any power to do so. He held out olive branch after olive branch. But in April of 1861, the Southern states decided to take it into their own hands, and they attacked. They very ceremoniously fired the first shot from Charleston, from the battery there in the city, against Fort Sumter, which was a federal outpost. And that was the beginning of our Civil War, and that was the situation that Lincoln encountered. In fact, it wasn't even Fort Sumter that was the first thing he encountered. Very importantly, as he was on the train from Illinois to Washington, D.C., he received reports that the slaveholding state of Maryland, which was to the north of Washington, D.C., had lots and lots of secessionists, lots of Confederate sympathizers, and that there was a plot against him, an assassination plot against him. And so Lincoln took precautions as he passed through Baltimore, which meant that he arrived late at night with little fanfare and went to the White House directly to assume his duties, for which he was ridiculed and criticized. But that was how seriously he took the situation. And if you look at a map and you look at where Washington, D.C. is, carved out of the states of Maryland and at that time Virginia, you see that not only was it directly opposed to Richmond, which was what, 100 miles away, something like that, a day's ride away, 2 days ride away, it was surrounded by slave-owning states, and so extremely vulnerable to encirclement. And that actually was probably the first constitutional decision that Lincoln had to make. Having arrived in Washington under threat of assassination, seeing the secession crisis move forward, Lincoln did his first extremely controversial constitutional thing. He suspended something we call the writ of habeas corpus. Originally, he only did so in Maryland, around the railroad in Baltimore and through the state, to protect incoming Union troops who were coming to Washington, D.C. to defend the Capitol. Now, what is habeas corpus? Why is that so important? Habeas corpus is commonly called the ancient writ. It goes all the way back at least to the Magna Carta in 1215. And it means, literally translated, produce the body. So a writ of habeas corpus is a vehicle by which a person who is imprisoned can bring an order signed by a judge to whomever is holding that person in prison that says, bring the prisoner to me, to the judge, and then explain to me why you are holding this prisoner. So the writ of habeas corpus is it's a vehicle by which prisoners can vindicate their constitutional rights. It's extremely important. It was extremely important then. It's extremely important today. And so the Constitution provides that the writ can only be suspended in extreme circumstances, and arguably only by Congress, though it's a little bit vague. It's written in the passive voice. Well, Lincoln took that vagueness and said, we're in an extreme circumstance, and I, Abraham Lincoln, am going to suspend that writ. And so round up the usual suspects, and he sent the army out And Southern sympathizers and Confederates and anybody he suspected of opposing him to the point where they were going to commit acts of mayhem and violence, they were just put in jail. And that was true of a lot of Southern sympathizers, including members of the Maryland legislature in 1861. And so you can see that was extremely controversial. It's extremely controversial to this day. Was that justified by the emergency, by the geographical position of Washington, D.C., by the threats to Lincoln's own life? People debate it to this day. So the suspension of habeas corpus is one of those things that people will say is one of the unconstitutional things that Abraham Lincoln did. The other great thing was in response to Fort Sumter. In response to Fort Sumter, Lincoln did a lot of things, but one of the things he did was impose a naval blockade on the South. The South didn't have a lot of industry. What it had was a lot of agricultural products, notably tobacco and cotton, that it exported to places like England, and then in return received manufactured goods. Well, Lincoln said, no more of that. We're going to blockade your ports. Well, under international law, that is an act of war. And of course, under our Constitution, only Congress can declare war. Well, where was Congress during all of this? The suspension of habeas corpus and all of this naval blockade. Well, they weren't in session. Unlike today, Congress was very much a part-time institution then, and they weren't in session, and Lincoln didn't call them back into session. I've spoken to our own expert on Lincoln, Charles Hubbard of our history department, and he laughs whenever people talk about that. And he says Lincoln didn't want Congress in session. He wanted to do what he felt was necessary. And that was in some sense his constitutional excuse. Another thing that he did while Congress was not in session was he simply said, I want 75,000 volunteers for the United States Army. Well, okay, it's an emergency. But his Secretary of War, Edwin Stanton, said, Mr. President, doesn't the Constitution say that only Congress can raise armies and navies? Only Congress can appropriate money for that purpose? And Lincoln said, yeah, just go ahead. Just go ahead. Bring the troops in, train them, give them their equipment and their food, and we'll worry about Congress later. So that was another huge expansion of the president's power. Now, with regard to all of those things that he did early on, eventually Congress came back to Washington, D.C. in the summer of 1861. And over the course of the next months, it essentially blessed all of those things Lincoln had done up to that point. But there was a significant period in 1861 when he was acting unilaterally, doing things that the Constitution seemed to prohibit in the case of habeas corpus, or to delegate to other branches of government in the case of raising an army or declaring war. And he was doing those things based upon his sense that there was a national emergency. Perhaps the last thing that I'll mention here before we open it up to discussion and questions is what's alternately considered Lincoln's greatest accomplishment, or his most unconstitutional action, and that was the Emancipation Proclamation. Now remember, slaves are property, and taking slaves away from their owners without compensating those owners violates the Fifth Amendment of the Constitution. And Lincoln very much believed that. But as the war went on, as the war went on, emancipation started happening by itself, all as early as 1862 and probably even earlier. As Union forces clashed with Southern forces, slaves would run away from the Southern lines and they would seek asylum with the Union. And so individual commanders were faced with these slaves running away who said, "Save me." And many of those commanders said, "Well, sure." In fact, there was one notorious incident, I believe it was in 1862, early in the war, where there was a battle going on in Virginia, and a Northern commander captured a significant number of slaves. And remarkably, under a flag of truce, the Southern commander rode up and made a formal request for the return of his property, his slaves. And the Northern commander, in real life and his civilian life, was a lawyer. And so he did what lawyers do. He said, let me think about it, come back tomorrow. And the commander thought about it. And next day, when the Southern commander showed up again wanting his slaves, the Northern commander said, well, sorry, can't help you. You say these things are property, right? These people are actually property. Well, then they are what I'm going to consider contraband of war. So just as if I had captured some of your donkeys or some of your wagons or some of your weapons, these are things I'm not going to give back to you because you'll just turn around and use them against me. And so, no, you say these slaves are property, fine. Well, then I'm seizing your property as contraband of war. This happened all throughout the battlefront. Famously, it happened in the state of Missouri, which was very much a border state, very much a state where these controversies were raging. And the commander, the military commander of Missouri at one point actually issued a proclamation emancipating all slaves in his military district. Lincoln actually slapped him down for that. He said, no, 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 if anyone's going to do this, I'm going to do it. You don't have this power, stop. So Lincoln was very, very concerned both about his constitutional power to emancipate slaves and about the political consequences of it. Because remember, not all of the slave-owning states has seceded. We've already talked about Maryland, which is to the rear of Washington, D.C. It's a slave state, but it had not seceded. Maybe it might have, but Lincoln prevented that with his actions. Even further north was the state of Delaware. It's a slave state, again, to Lincoln's rear. To the west, you have Kentucky, right on the battlefront. And then further west, you have Missouri, another slave state that stayed in the Union. And there's an old story, which I think is basically true, where a number of abolitionist preachers came to Lincoln early on in the war, and they said, Mr. Lincoln, if you emancipate the slaves, God will be on our side. And Lincoln supposedly responded, I would love to have God on our side, but I must have Kentucky. So it was a practical consideration as well as a constitutional consideration that Lincoln was very, very hesitant to use his own powers to emancipate slaves. It was only after great deliberation and after giving warning in the fall of 1862 that he was about to do it, that Lincoln finally, on January the 1st, 1863, issued the Emancipation Proclamation, which very importantly did not emancipate slaves in loyal states or in areas occupied by the Union, only in states in rebellion. Now, people have criticized this. They said Lincoln freed slaves where he had no power, so it was meaningless. Oh, no, no. You understand his proclamation from a constitutional sense when you realize he was using his commander-in-chief powers to seize contraband of war. And so that's what he did. He said, if you're in an area in rebellion and you're using your slaves to fight against the United States, well, guess what? You no longer own them. And as soon as we get down there, we're taking them away from you. Very controversial to this day, very controversial at the time, and possibly only a temporary measure that would have lasted as long as the war lasted, which is why Lincoln was so adamant about getting the 13th Amendment abolishing slavery passed and ratified. If you've seen the movie Lincoln, you've seen a fairly accurate account of Lincoln's determination to abolish slavery through the constitutional amendment method. And a good deal of his reason for that was because he was afraid that the Emancipation Proclamation would be challenged and reversed after the Civil War was over, and then we'd be back where we started. All right, then, I've talked a while, a half an hour or so, and I think hit the highlights of Lincoln and the Constitution and the very controversial actions that he took. And I'm very, very happy to answer any questions or discuss these things with you as you wish. Sheila, do you have any questions?
I do not at the moment here. I think you've done a great job on that. If anybody has any questions, you can type them in, or you can unmute and ask Professor Harris a
Absolutely.
question.
Don't
Now's your
be
chance.
shy. Don't be shy. I'm actually a fairly friendly fellow. I will
I would
not
agree.
laugh at you, and I will not bark at you. I'm very happy to answer any questions you may have. Or we can all just sit here and look at each other, because we don't spend enough time looking at each other on Zoom.
Professor Harris, I have a question. I did a little bit of research on Lincoln when I worked at the Lincoln Library at one time as an intern. And could you speak somewhat? I think when I was reading some of these Lincoln magazines, there were some articles as to whether the states had the right to secede from the Union, it being a voluntary union, and whether Lincoln had the power to declare war on the states.
Excellent question, Noah, and very good to hear from you. Glad you're here with us today. Noah is one of our distinguished graduates of our law school, a recent one, and a distinguished alumnus of this university as well. And so glad to have you with us, Noah. Yeah, did the southern states, does any state today have the right or the power to secede from the Union? Well, the Confederacy made a pretty compelling case when they said, well, that